Okay, I wanted to welcome everybody to the 2019 Mannor Law Group Annual Client Update Meeting. We're so glad everyone could be here today. I just wanted to go through some of the agenda that we're going to have this morning. I want to talk to you a little bit about what's been going on in our office, give you some updates. Lisa's going to come up and talk to you about Medicare and what you need to know. And then we're going to cover some state administration must-knows, and Melissa's going to talk about your decision-making documents, your powers of attorney, those important documents that you need in your lifetime. Also, Bob and Kelly are going to come out and talk about how your legal plan works, kind of go over some of the hot topics and some of the law changes for this year. And then everyone has a memory jogger on their table. We'd like you to fill that out at the end, and Bob will tell you all about that. So, to get started, Bob's always wonderful about bragging about our office and his staff and how wonderful we are, right, Bob? So it's our turn to brag about him. Bob's been very busy this year. We have, for the 8th year in a row, been voted best law firm in Grand Blanc. So if you voted, thank you. We appreciate it. Love your support and all your referrals. Also, Bob's been out teaching other attorneys. He's not just a great lawyer, he's a great lawyer teacher. So he's been, in the spring, he was at the 17th Annual Spring Conference for the Elder Law and Disability Rights section of the State Bar of Michigan. And then this fall, Bob's a featured speaker at the Elder Law and Disability Fall Conference. So he's out doing good things in the law world. And we had 2 big events this year. I don't know if anyone's heard of our boot camp. This year was our 6th annual Elder Advocacy and Law Boot Camp. We're out there educating social workers and nursing home administrators. And they earn continuing education credits. So we did one in in Oakland County, and we did one here in Genesee County. And boot camp has been such a success, it's gone viral. So Bob is national now, spreading the good word about his boot camp. He's been honored nationally, educating social workers and nursing home administrators, and he's connecting with attorneys across the country to set up their own boot camp programs to also educate the social workers and nursing home administrators in their area. So, way to go, Bob. And we can't get through today without bragging about Ina. She has been out all over the community. I hope some of you have gotten a chance to see her. She's our registered nurse, and she's been out doing different speaking engagements in the community about medication madness and tips to prevent broken hips. So if you have a community group, church group you'd like her to speak at, let us know. Give us a call and we'll get you in touch with her. And Ina's been busy herself this year. She was part of an honor flight in May. It's a wonderful experience that she had. For those of you that don't know, the Mid-Michigan Honor Flight's a regional hub of the National Honor Flight Network. Their mission is to transport America's veterans free of charge to Washington, D.C. to visit all the memorials that are dedicated to honoring their sacrifices. Our Ina was a guardian on May 22nd flight, where she assisted other veterans with making sure they had a safe and memorable experience. After the flight, Ina was awestruck on what an incredible experience she had with being a guardian for the honor flight. So Ina's brought some applications today if you're interested in being a guardian for any of the future flights. Just see Ina on that. And we have an office baby. So Kelly King-Penner, our attorney, had a beautiful baby boy, Benjamin Penner, on February 24th. And we just are adoring every time he comes to visit us. So we're like grandparents. We squeeze them, smell them, and give them back. So, all right. So, and we're happy to have Kelly back, too. That was a long maternity leave without her. All And for our Oakland County friends, we have moved our Rochester office. Don't worry, we're still in Grand Blanc, but our Rochester office has moved to a new location. We're at 805 Oakwood Road, so we hope to see you over there soon. And once again, we're a sponsor of the Walk to End Alzheimer's Walk. It's coming up, and we would love for you to join us. It's a fun event, so much fun. And this year they're doing it at the U of M campus, so it's going to be a beautiful walk. It's going to be Saturday, September 28th. Registration's at 10 a.m. Let us know if you're interested. We can give you more information. And we have some new faces at Mannor Law this year, and I would like to bring Bob up, and he can brag all about all their talents they've brought to our office.
We're always looking for great people, of course, and we got some really extraordinary people that joined us this year. So the gentleman there, it seems like there's not very many men that work at the office for some reason, but finally we have another man at the office, Gregory Raymond, and he has a very interesting background because he was mostly engineering management at Chrysler. So you say, okay, well that seems like an odd transition. But the goal, he's our operations manager, and what he is doing for us is trying to make sure that we keep things as efficient as possible. So he's kind of our efficiency expert. And we're learning all kinds of new things that maybe some of you learned in the automotive industry, but is not very often applied to law offices. But we are fortunate to have his talents to help us figure out to provide the most efficient and make sure that we have quality control and all of the things that he'll bring those talents to our office. So we're really excited to have Greg. Savannah is my executive assistant, and she is a rock star. She comes with so much experience in dealing with lots of different areas. She actually did some things with regard to some lawyers and counselors and things like that. She actually had some recruiting background, so she's been helping us with hiring and finding the right employees, and she's really just a fantastic addition to the office. And then finally, Liz. Liz just joined us, about a month ago, maybe less? And so we're really excited to have Liz. If any of you have had any experience with our public benefits department, or sometimes we call it the Medicaid department, it is a big part of what we do. We help folks that are facing a long-term care crisis make sure that they're going to get quality care, but also to make sure they can afford it, right? And many of us have heard the term Medicaid, and you think, oh, my goodness, I wouldn't want to go on Medicaid because I'm going to lose everything. Well, you should know that's not true. That's what we help people with, to make sure that we can protect you, protect your house, protect your assets, protect your spouse, protect your family. And so we've had Amy, which we've left back at the office to work, but she now has an assistant, Liz, and Liz comes to us from actually the Medicaid office of another state. So she just moved back to Michigan, but she was working for the government Medicaid office in a different state, and so she comes with a good amount of experience and knowledge base already. So we're really excited to have her, and she's a great fit for our office. So we're going to get right back into the substance of it, though. And last year you heard from Lisa. She talked a little bit longer about Medicare. Medicare is one of those things that we kind of think we know, but then we don't, right? And it's very difficult to figure out what supplement. Often when I hear people talk about, okay, well, I've got Medicare, what kind of insurance do I need? What kind of supplemental insurance? Sometimes it's provided by our retirement, but if it's not, how do we pick? How do most people pick? Well, they talk to their neighbor or they talk to their sister and they say, well, what'd you get? And, well, maybe I should get that. Well, that's actually not ideal, because the whole point of Medicare and getting supplemental insurance is to have it tailored to what your needs are. And so your sister's needs are not the same as yours. Your spouse's needs are not the same as yours. So most of the times we're going to have husband and wife have the same insurance coverage. Now, of course, that before 65, we had a family policy, right? And everybody in the family had the same policy. But after you turn 65, that's not necessary anymore. In fact, it's not designed that way. So if you have the same insurance coverage as your spouse, you might want to look and see if you should be getting something more specific to you. So Lisa's going to come up. She kind of went into a longer description of all of that last year. She's going to give you a little quick reminder of that and kind of give you some ideas for how do we make sure that you're going to get the right coverage for you. So Lisa, there's no stairs here, so you might have to go around the long way.
Good morning. Good to see everybody today. As Bob mentioned, I'm going to talk to you a little bit about Medicare. What I'm going to focus on is the Medicare open enrollment period. So it's that time again, and you'll know for certain that it's that time because your mailbox is going to be flooded with all the advertisements, and every ad on the TV and the radio is going to be about Medicare. So it's time to look at your options and make some choices. Oh, what did I do? Okay, there we go. Okay, so what is this Medicare open enrollment period? So this is a time where you can review your changes, or review and make changes to your Medicare plans. You can select a new plan if you want to. You don't have to, but it might make sense financially for you to do so. So it's a good time to consider all of your options. The plans do have the right every year to change their costs, to change their coverage, and to change their provider networks. So if you have a particular doctor that you want to stay with, you might want to look and make sure that doctor's still in your network. So how do you know if you need to make a change? So people in Medicare, in the health plans, and also in the prescription drug plans are going to receive a couple of statements. One is going to be an evidence of coverage, and that's going to tell you what your coverage is. The other one is going to be an annual notice of change, and this is going to let you know what's different about your policy for the following year. So those notices are going to go out by September 30th. Some of you may have already received one. If you did, I encourage you to review it, see if there's anything that's going to change that affects you. So why review your coverage? A lot of people say, well, I'm happy with what I have. Why should I even consider another one? Well, you want to make sure that your current coverage is meeting your health needs. So did you have a change in your health status over the last year? If you did, it might be a good idea to take a look at some different options. You want to make sure that all of your medications are covered. So every Part D Medicare plan has a list of covered drugs called a formulary. And you want to make sure that all of your drugs are on that formulary, or you're going to be paying some high out-of-pocket costs. You want to see if maybe you can manage your out-of-pocket costs a little bit better. Are you in a PPO and maybe an HMO is going to be more effective for you, or different Part D prescription drug plan? And then again, what I mentioned earlier, real important to people is having their doctors in network. So if you've had a change in health and you're seeing a specialist now that maybe you weren't seeing before, you're going to want to make sure that that specialist is in network. So what happens if you decide to make a change? So any change that you make during this open enrollment period will go into effect on January 1st. You'll be mailed new materials and you'll get a new card. And then enrolling in a new plan, whether it's an Advantage plan, a managed care Advantage plan, or a prescription drug plan, will automatically disenroll you from your old plan. The only thing you're going to need to do is set up a method of payment. So you can set it up as an auto deduct from checking account, you can put it on a credit card, you can have it auto deducted from your Social Security. So how do you find out what's going on for the next year? Well, the 2020 plan information will be available pretty soon, beginning of October. Excuse me. You can't make a change until October the 15th, but you can start reviewing your plans. You can search those plans on Medicare.gov using their Plan Finder tool. You can contact Medicare directly and speak with a representative, or you can contact your local area agency on aging. We've provided an 800 number, and that is a geo-routed number which will get you to the right area agency based on the area code that you're calling from. So we know that there's always changes in Medicare. It's a very fluid program. So one of the changes that I want to bring to people's attention, starting in January of 2020. So if you are an individual who's in original Medicare and you purchase secondary insurance called a Medigap or supplemental insurance, beginning in January, insurers will no longer be able to sell Plan C and Plan F. And those were the two most popular products that people purchased. So if you're in Plan C or Plan F, you can remain, continue to pay your premium, and you'll be in the plan. But no new plans are going to be offered. And so what that means is we're going to be seeing a shrinking pool of enrollees, and that will eventually affect the premiums. So if we have a smaller, more aged pool of enrollees, then the premiums are going to go up. So just something to kind of tuck in the back of your mind. You may see that coming down the pike. The reason that they opted to do this was a kind of a cost containment issue. They feel like the plans that cover absolutely everything, people were sort of overutilizing medical services. So they're not selling plans that pay the Part B deductible, and that's Plan C and Plan F. The Part B deductible this year is only $185, so it's not a huge deal, but that was their rationale for that. So that is all that I have for you on Medicare, but up next, we're going to welcome Savannah to the podium, and she is going to be talking to you about estate administration.
All right, good morning, everybody. I'm Savannah, one of the new folks that you saw a few slides ago, and I'm just going to talk to you for a few minutes about estate administration. Now, you're all here today because you took the time to prepare for what happens after you're gone. And this is just kind of further planning and making sure that your family's taken care of in the way that you would like. So the first thing that I just really want you to put into your mind is that estate administration is not easy. There's really a lot of steps involved in the process. And our goal here at Mannor Law Group is just to make that process a little bit more manageable, well, actually a lot more manageable for your family. So there are a few reasons that we feel that estate administration, coming to us for that, will really help your family or whoever you've left in charge. And the first reason is that the first meeting is free for your family. So there's no risk for whoever's left in charge after you're gone to come in and talk to us about all the steps involved with your process. Because every little process for every one of you is going to be different than the person sitting next to you. So we'll be able to talk about that with whomever you've left in charge. What's involved, what steps are there, and what they're looking at. They can decide then if they would like to just go forward and doing that on their own, or if they would like us to take over and help out. But that first meeting is totally free. The second reason is it's a huge time saver. So your family, they're already going to be dealing with, losing you. Well, that's hard. So we don't want it to be even harder for them by managing all of this, plus grief, plus their normal lives. So it's actually important to note that it can take 16 months to 2 years to settle an estate. That's a long time for whoever you've left in charge. So we come in and we help streamline that process for them. We make sure that it's managed and that they can handle it with everything else that they're handling in life, because we do it for them. So there's another important reason, and that's that expert guidance. So it can take 500 to 800 hours to manage the estate. Again, that's a long time, a lot of steps, and a lot of moving parts involved. So our team comes through and helps guide whoever you've left in charge to make sure that all of those steps are being taken care of, while of course saving them time. The fourth reason is managing creditors. And this is something that a lot of people don't think about with managing the estate. So just real quick, I'm curious to know, raise your hands if you enjoy dealing with creditors. Okay, you know who else won't? Whoever you've left in charge. And they're a hassle. I mean, they really are. So on top of everything else, your loved one is going to have to sort of bear that weight of dealing with the creditors and all of their questions, and they can be a little misleading from time to time too. So it's really important to make sure that you've got someone in place to deal with that, to make sure that they're protected from that, and to make sure that everything is fair as well, because they're not always fair. The fifth reason is to avoid mistakes. So as I've said a few times, there are a lot of moving parts and a lot of steps involved with settling an estate. So we come in and make sure that none of those easy things to look over are looked over. We make sure that everything is done, all the I's are dotted, all the T's are crossed exactly how they need to be, so that the process can just end when it needs to end. And then the last reason, and this one is arguably the most important, the risk of failure to finish. So again, so many steps to this process that it's really easy to overlook something. And a lot of people think that they've actually completed all of the steps, when in reality they haven't. So it can come back and there can actually be issues for whomever you've left in charge. Sometimes they can be responsible for things. There's a lot of things that we have to watch out for those that we've left in charge. So again, Mannor Law Group makes sure that the process is done. Everything is settled and your family can move on. So remember, you've already taken the steps to protect your assets and protect your loved ones. Now you can take it a step further and make sure that they know to contact us when the time comes. So to help you and to help them, remember, we've given you in that little packet of stuff on your table a flyer, and it looks something like that. So we actually ask you to stick it right in your binder, first page, so that way whomever you've left in charge opens that, they can see it right there. Oh, this is what I'm supposed to do. That way they don't have to look at your binder just feeling overwhelmed. They know exactly what to do next. So I encourage you, some of you I saw brought your binders, stick it in there right now. That way we don't lose it on the way home. And then we also want to make sure that you know to tell whomever you've left in charge that we give them a free educational meeting. We actually have 2 of these meetings. So we'd like you to invite whoever you've left in charge, whether it's your kids or family members or anyone else. We encourage you to let them know. And again, on your table, we've given you little flyers that have these dates. There's Tuesday, October 8th at 9 a.m. And then Thursday, October 17th, that's at 3:30 p.m. So one in the morning, one in the afternoon. And again, this workshop is for the person that's in charge of administering your estate. And we actually ask that you, I know it's sometimes tempting for you to want to come with them, but we've actually found it's a little bit more productive of a meeting if you're not there. Sometimes they're shy, they don't want to ask certain questions, that might, there's a lot of heavy talk that's going on sometimes. They don't want to lose you, they don't want to talk about that. So we found that it's better if you just encourage them to come. And it's a small space, so we want to make sure that we have enough room. So please encourage them to call ahead and RSVP so that we can save a place for them. Okay? So thanks again. I appreciate you all listening to me today about this, and we encourage you to stick that paper in your binder. It's the last reminder. So next, I'm going to have Melissa come up, and she's going to talk to you about some other important legal documents.
Good morning. I'm going to give you guys a quick refresher on your power of attorney documents. So if you're sitting here today, you very likely have them. They're towards the back of your binder. We also refer to them as your lifetime documents because you have listed an order of helpers who can help you during your lifetime. And so the 2 ways that they can help you would be with your financials and with your healthcare decisions. So the first one is your financial power of attorney, also known as the durable power of attorney. This would be for things like paying bills, signing checks, going to the bank, filing tax returns, anything you could think of. So this document is effective immediately, so we don't want any of your helpers to have to hop through any hoops to help you. So if you decide, I'm going to go to Cancun for a month and maybe I'm going to extend it for 3 months and you want somebody to help you out while you're gone, they can help you. Okay, so also towards the back of that binder is, or the back of that document are your extraordinary powers. So in there it says if your plan should change for any reason, if your health changes, your finances change, if for any reason why the plan that you have in place now is not working, and you're unable to come in and talk to us about a new plan, the people you've listed in that financial power of attorney can come in and have that conversation for you. So that's why it's pretty extraordinary. The next document is your health care power of attorney. So you're always going to make your own health care decisions unless, of course, you're unable to. So if you're in the middle of a procedure and the doctor needs somebody to consent, it helps if I'm on the slide, I apologize. If you're unable to make your health care decisions, then the people you've listed in that document can step up and advocate for you if you need them to. That one becomes effective when you're unable to speak. So really, it's not until you're unable to make your own decisions that that one becomes effective. So how often should you update those power of attorney documents? If at any time the order doesn't make sense anymore, it's a good time to give us a call and talk about that. So if your order of helpers doesn't make sense because someone has passed away or because someone has moved away or anything of that sort, you can give us a call and talk about that order and possibly updating those documents if necessary. So what is a guardianship or a conservatorship proceeding? These are court proceedings. So if you're sitting here and you've signed your power of attorney documents, this should not come into play for you. This is where someone has waited too long and they have not signed power of attorney. So they haven't given anyone the legal authority to step up and help them and make those decisions. And now we need to go to the judge and we need to say this person is unable to make their own medical decisions or they're unable to handle their finances anymore. Can you please give someone the authority to do that on their behalf? So that guardianship proceeding would be if somebody needs help with their medical decisions or managing their well-being. That's when the court would appoint someone to be their guardian. And again, that's only if they haven't signed a health care power of attorney. The conservatorship proceeding comes in if they're unable to handle their finances, and we need the judge to appoint a conservator to handle their finances. You've avoided these things hopefully by signing those power of attorney documents, but something to keep in mind are people you know who maybe have waited too long and haven't signed them. If they need somebody to step up and advocate and they need somebody to be appointed guardian or conservator, that's a matter that you can call us about. And then the other scenario is thinking about your loved ones, your kids, your neighbors, your friends, people who have not signed power of attorney. These are proceedings that they could be facing if they don't sign those documents. So those are some things to keep in mind. So next, you can welcome with me Bob Mannor. He's going to talk to you about other documents in your binder.
Okay, I like to move around a little bit. So if I'm not using the mic right, or if you can't hear me, or if I'm too loud, somebody just kind of wave me down, and we'll try to do this. So most of you will remember some of the silly pictures that we explained stuff with, right? So we've got the little red wagon, and we've got the lockbox, and we've got the funnel. So we're just going to go through those just as a sort of a reminder of how this all works, and some of the importance of what you still have to do, okay? One of the big reasons why we have this meeting, there's a lot of reasons why we like to have this annual meeting. It's just an opportunity to kind of touch base with you, remind you about what you have and what it does for you, talk to you about any changes that are going on, and make sure that it's maintained. But part of the thing that you got to remember is legal documents are just tools. I joke sometimes how I'm not overly handy at home. I can't, remodel a bathroom. I can do this stuff. I can't remodel a bathroom, but sometimes I'll think that I can, and I'll buy some fancy tool that I see on an infomercial. And somehow I think by getting that tool, and they made it look so easy on that commercial, that I'm going to be able to just take that tool and remodel my bathroom. And the one time I did that, I broke the tool the first time I used it. So my point on it is these legal documents are just tools, right? And you have to know how to use the tool. This has been something that we've been trying to do forever. And I think one of the things that gets neglected, because a lot of people assume that, well, I went to the lawyer 20 years ago, I put the documents on the shelf, and so that's it. It's like the magic pill that's going to solve everything. I never have to look at it again. And most of the time, that's not how things work. It's actually kind of similar to saying, but I went to the doctor 20 years ago, and they said I was healthy. Things change, right? And so we're going to talk today about just kind of making sure we're all on the same page about what the legal documents do. And then we're going to talk about that tool and what you still need to do on an annual basis to make sure it's going to work the way that we said it was going to work. And I don't have control over that. A lot of times people will come to me that aren't clients. They'll come to me and say, I have this trust, I have this will. Can you just look at it and tell me if it's going to work? And my answer is no, I can't. And it's not because of the written words on the page. It's a tool that you have to use, and if you're not using it properly, then it's not going to work properly. And so that's what this annual meeting's always been about. We got to make sure, and it's not difficult, but we're going to make sure the very last thing we do is what we call our memory jogger, and that's where we're going to go through and make sure that your tool is up to date and it's sharp and you're using it right. And if you check yes on any of the boxes on that memory jogger, that means that we need to contact you and just make sure if we need to sharpen that tool or if we need to do something to make sure that's going to work properly. So let's set the proper foundation here. So the first thing, a lot of people, they grab that binder and they say, here's my will. Well, true, there's a will in there, but there's a bunch of other documents too. So I kind of want to just start off with the will. Now, most of you know by now that if you need to look at the will to see where something goes, it means it's going to go through a full probate, a full decedent's estate, all right? And most of the time, I was at some of my friends, we were presenting last week, actually, last Thursday and Friday at the annual Elder Law Institute, and some of my friends were doing another presentation, and they talked about the three horsemen of the apocalypse when it comes to estate planning. And I thought I'm going to probably steal that from them because I thought it was a pretty cute way of describing things. They said the three horsemen of the apocalypse when it comes to estate planning are probate, taxes, and long-term care. And that's it. Those are the three things that we're worried about. Staying out of court, make sure we don't pay too much in taxes, and what if we have a long-term care need and not losing everything we have to a nursing home or something like that. So the first thing is a will does go through probate. So why would you have a will when one of the three horsemen is we're trying to avoid probate? Why do you have a will? So the will, in most of your plans, one of our philosophies is we don't want to go through probate. We don't want to go through that court system. And you're going to see a video in a few minutes about an example of how probate courts can run amok. And maybe you guys have paid attention to some of the things going on in the media right here in Michigan about probate. And so one of our goals is to avoid probate. We have to have a backup, okay? Why do we have to have a backup? Well, what if you break the tool? You're not going to break the tool, but what if you don't use the tool properly? What if you forget to do your homework? What if you don't come to the annual meetings? What if things go by and you don't keep things up to date? Now, it's not hard to keep it up to date. That's why we have this meeting. We're going to give you instructions to make sure it's up to date. But if you don't do those things, then we need the will as a backup. Now, if anything ends up going through the will, is it going to go through probate? Yep. Yes. So the will that we have, we call it a pour-over will, because what it does is it pours it back into the trust, but it still means if we have to use that to pour anything into the trust, still means that asset is going to go through probate. That's why it's so important that we do our homework and that we go through this memory jogger and take it seriously. And you tell us if you buy a new house. You tell the bank if you switch banks, things like that. So we're going to get through that in a minute here. But, the will is going to be, it names who gets what and who's in charge. It only controls things in your own name when you die. and it must go through probate, open a minimum of 5 months, controls with the probate court, not the family, and everything's a matter of public record. Now, I want to be extra clear here. Does that mean that your stuff will go through probate? No, that's the whole goal. That's one of the reasons why we did the planning that we did, to stay out of probate. But if something goes wrong, we have this as a backup. Okay? All right, so then we have the little red wagon. And why do I call it a little red wagon? Because it's not a funnel. So the funnel catches things and gets it to where it needs to go. So it catches your house if you didn't plan properly for your house, and it'll funnel it down to the kids. But if we don't want to have it go through probate, then we look at the trust. And the idea of the trust is it's not a funnel, meaning it's not a catch-all. So how does the wagon work? You got to put the stuff in the wagon. So when you came in, if you had a house, we put the house in the wagon. If you sold that house and bought a condo, is the condo in the wagon? Probably if you didn't tell us about it, it's probably not in the wagon, and now that condo is going to go through probate. So that's why it's really important to let us know if you buy a condo. Now, if you tell us before you buy the condo, when you buy it, we'll give them the instructions to make sure it's in the trust. If you forgot, then tell us afterwards, and then we'll put it in the wagon. But you can buy it in the wagon. You don't even have to really involve us, other than we'll give some instructions to the closing agent. But if you forgot, no big deal. We can fix it as long as you're still alive. You got to be alive for us to put stuff in the wagon. So that's one of the things, and one of the reasons why we have this annual meeting. One of the most important things, a lot of times people think about a trust, and they used to think, I used to hear a lot of times that the reason for trust is for estate or death taxes. Well, that's not true anymore. Estate and death taxes really have nothing to do with trust, because, at least in Michigan, we're not going to pay any estate and death taxes unless we have over $11 million. So if you've got more than $11 million, come see me. But I don't know a lot of people that have more than $11 million. You raising your hand and you have $11 million? Great. Go ahead. Yeah, good question. So cars we don't usually put in the trust, and there's 2 reasons why. Number one is if it's easy to transfer after death. You can do it right at the Secretary of State's office through an affidavit. Number 2 is they may try to charge you some transfer taxes if you put the car in the trust, and we don't want you to have to pay transfer taxes. So we usually don't put the car in trust unless you were at Back to the Bricks and you have that classic car that's worth $100,000. Then yeah, we probably should put that car in the trust because it's worth $100,000. But if it's just a hobby car and it's worth $10,000, even if you were at Back to the Bricks, we don't have to put in. So anything that's as much of an investment as it is a car, then yeah, we'd put that in. But what about your bank account? My answer is yes. Now, a lot of people ignore me on this one. They say, well, I don't want to put my checking account. That's fine, but my question is why? And some people say, well, I don't want to have it on my checking account that I have a trust where I have to reorder checks and things like that. Then don't. Don't put on your checkbook that you have a trust. You don't need to. You just put your name on your checkbook. So when you write a check, you're writing a check from you, even though the account's in the trust. It's nobody's business that you have a trust. It should just be at the computer at the bank. They would know you have a trust, but anybody you write a check to doesn't need to know that you have a trust. Okay, that's not how this works. You can just put your name on your check, the actual check. So I say, why wouldn't you do it? And the reason here, number 2, is the main reason I say that is handles during disability. Just by show of hands, anybody have an opportunity? And I use that word knowing that it's probably more of a ordeal than an opportunity, but the opportunity to step in for your parents and take over kind of paying your parents' bills and things like that. And I have to, a lot of you, yeah. Is that an easy thing to do or a less easy thing to do? It depends. And the answer is, if they had everything lined up in a trust, it should be relatively straightforward to get the banks to comply. Now, sometimes you get the errant teller or you get the errant manager and you got to go above their head, but legally it's going to be the easiest way to have everything organized with central management. That's the whole point of a trust is central management, okay? And it makes it clear who's in charge. Now, that doesn't mean that the teller at the bank understands that. So sometimes you have to call us or take it to the next level or whatever, but legally they can't deny the trustee of a trust access to the account. Why can't they do that? Because they've already agreed to the terms of this contract. What if you go in with the power of attorney? Anybody ever have trouble trying to use a power of attorney? Yeah. And why is that? Well, banks will look at that and they say, well, I don't know anything about this power of attorney. How do I know this wasn't fraudulent? How do I know that you didn't sign this? They legitimately, should be looking out for their clients or customers and making sure they're not being subject to fraud. But the difference between the trustee of a trust and the agent under a power of attorney is the agent under the power of attorney, they don't have any previous relationship with the bank. The bank's never previously agreed to accept that power of attorney. With a trust, for the account to be part of the trust, we would have had to go on to the bank, give them the trust documents while we were still healthy, okay? And then, when you're not healthy, then they say, well, we already accepted the terms of the trust. We have to deal with whoever's in charge of that trust. And then you might need a letter from me. It's called a certificate of trust saying, this is the trustee. So that's often the issue. If you have trouble working with the bank on a trust, you probably need a letter from an attorney saying, I reviewed everything, here's who's in charge of this now, and you take that, it's called a certificate of trust, you take that to the bank and they have to deal with you because they've already accepted the terms of the trust. Okay? So that's handling it during disability. Yeah. That's a great question, and it's happening more and more that the banks will just, when we go and say, okay, here we have a new trust and we're setting this up, and now you got to deal with the terms of the trust, and the bank refuses. You want to take that one, Kelly? A lot of times what we say is, okay, well, thanks for being our banker for all these years, but, if you're not going to be reasonable, maybe we got to go to a different bank. Now, most banks, what they'll allow you to do, so I'll pick on one bank, and it's actually where we do our banking, so I'll pick on Chase. Chase will say, we're not going to take your existing accounts and put them in a trust. What they will say is, you got to close all those accounts and open up all brand new accounts. And I say, oh, that seems like way too much of a hassle. So we can at least put a beneficiary, list the trust as a beneficiary, but it's not as good because it doesn't handle things during disability. So that's where you have to make a decision. Hey, I've been working with this bank all these years. We're just going to shoulder through it and just do it anyway and list as a beneficiary. Or sometimes people say, I'm just going to close all the accounts and open new accounts. Or some people say, I'm just going to go to a different bank. And those are the decisions you have to make at the time. But the reason why, and that's a hassle. Admittedly, that's a hassle. But it's better for you. Sounds bad because I'm putting the burden on you. It's better for you to have that hassle than for your kids to have that hassle later on, where it's going to be harder for them because it's still your account and you have these options. It's going to be harder for the kids to access it later on if we haven't gone through that. So there's always legwork associated with this, but when we do the legwork, it's going to make it so much easier if you get sick. It's going to make it so much easier after you're gone to settle things. Okay? Kelly talked to, Melissa? Kelly? No. Did you, Melissa? I got confused as who was talking about. No, it was Savannah. Sorry, Savannah was talking about it. Savannah was talking about how long it takes to settle estates. Well, it doesn't have to take that long, but often it does because of these things. These things that if we had done all the legwork when we were living, then it's going to be a lot faster and less expensive and hassle if we, after we're gone. And that's kind of the whole point of doing the planning in the first place and these annual meetings and your efforts. And so you guys are at the top of the heap here. You're the cream of the crop because most people don't do this type of thing. They don't sit here for an hour a year and make sure things are up to date and go through their memory jogger and make sure that they're doing, do their diligence to make sure that their family is going to have an easier time of things. So You really have done a good job with that. One of the things we want to point out about this trust, because a lot of people hear trust and they think, oh, well, that means that it's protected from the nursing home, or that means that that money is not going to count against me for veterans benefits. That's not true for this type of a trust, okay? Most of you would have the revocable trust, and that does not protect assets. It organizes, it manages, it makes it easier in disability, it makes it easier in death. It stays out of probate, but it does not protect them from the nursing home or qualify you for veterans benefits. All right. Then, a lot of you, these are options. So now, what we're going to talk about, so far we've talked about the will, we've talked about your financial or durable power of attorney, that was Melissa. We talked about your health care documents, which was Melissa. Now we're going to talk about some options that people have with trust. Now, not everybody has this, okay? When you came in, some people said, well, I want the base trust. I just want to organize things and avoid probate. Some of you decided what we call our enhanced trust. And the enhanced trust is where we're basically saying, okay, we want to provide some additional protections for our children. And so this idea of the enhanced trust is what I call generational planning. So we got 3 kids, Susie, Roger, and Danny. And then we've got our adopted 4th child. We'll call him Sam, Uncle Sam. And the idea, we'll talk about that first. For most of us, we're not going to pay death taxes, right? Because we don't have the $11 million. So we're not going to pay death taxes if we die in Michigan. Other states do have death taxes, but not Michigan or Florida. And so what we are concerned about, though, is your retirement accounts, like your IRAs, like your 401k, anything that's called a qualified annuity or anything like that, that was money that was in retirement that you haven't paid the taxes on yet. Okay, now the issue with that is, what happens when you pull money out of those accounts? What happens? You get taxed on it, right? What happens when you die? Do you think Uncle Sam's not going to collect the rest of the taxes on it? No, they're going to collect the taxes, and what they'd prefer is to collect all those taxes right then. But what happens if you collect all those taxes right then? What tax bracket are you going to be in? Yeah, higher tax bracket. So one of the things that this enhanced planning does is it says, okay, well, we can stretch those out. We can stretch those payments out to the kids and put them in lower tax brackets for years to come. Or we can even do it onto the grandkids. We're going to talk a little bit later in our law update about some changes in the law that is likely to occur this year or next year. But for right now, a lot of you have this in there that says we can stretch out those payments to the kids and not have to pay all the taxes at once. But what else can it do? So we say, okay, we got Susie. We love Susie, our only daughter. She's just a wonderful person. Not so fond of our idiot son-in-law, but wouldn't it be great if we could get the money to Susie and make sure that he never had a chance to get his hands on that, the idiot son-in-law? And now, yeah, we can do that. That's what we call our lifetime protector trusts. And then with Roger, maybe he has some financial issues. Maybe he has a failed business or something like that. And so we could have what we call our lifetime protector trust for Roger. So Susie and Roger get their share. They manage it. They're in charge of it. They can do whatever they want with the money, but the money is protected from divorce. Money is protected from even a current spouse. It's protected from creditors. Why is this allowed? Because it's technically still in your trust even after you die. It's just now in a subtrust for Susie that Susie's in charge of. It's in a subtrust for Roger that Roger's in charge of. And it makes it so that they have complete access to it. Susie could go and buy a house, and now even a divorce judge couldn't access that because it's still in that trust that mom and dad created, and the judge can't access it because it's your trust. It's not Susie's trust, even though Susie's completely in charge of it. Same thing with Roger. Danny's a little bit different. Danny maybe is on SSI disability. So if you're on SSI disability and you get an inheritance, what happens? You might lose your medical benefits. You might lose your disability payments. And so wouldn't it be great if we could leave something for Danny and make sure that he's not going to lose his medical or disability benefits? And you can do that. It's just a little bit different because Susie can be in charge of her share, Roger can be in charge of his share. Danny's not allowed to be in charge of his share and might not be capable if he was disabled from birth. Maybe he's, doesn't have the capacity to manage his finances or things like that. But we can put Susie or Roger in charge of it, make sure he still gets his share. It has to be managed for him in order for him to maintain his disability or medical benefits. So that's one of the options that some of you have chosen. Yes, please. Yeah. Right. Florida's pretty much Michigan. Yeah. Yeah. Right. Good question. So, what if you have assets in other states? Well, if you are a resident of Michigan, it's generally going to be Michigan. And if I always, kind of joke that Florida is just like a suburb of Michigan because there's so many people from Michigan that go down to Florida. But Florida actually has similar laws to Michigan. They don't have any estate tax. In fact, that's the reason Michigan doesn't have an estate tax, because Florida didn't have one. And so they figured out a long time ago, we're losing all of our seniors to Florida, and so we had to get rid of our estate tax so that people just wouldn't change their residency. And so, if you're a resident of Michigan generally. Now, the only exception to that is, and you can correct me, Kelly, if it's real estate in another state, that real estate might be subject to their estate tax. Does that sound right? It's interesting. I remember we had real estate in Massachusetts. It was significantly more expensive to get that house titled into the trust in Massachusetts than it was in Michigan. There's just a lot more regulations. The other thing, this is just random knowledge, that there was actually just recently a Supreme Court case. Supreme Court case said, I think it was New Jersey, if I remember right. New Jersey was trying to tax people who were a beneficiary. So your child lives in New Jersey, mom lives in Michigan. I don't know the particulars of the case, but it was another state. And New Jersey was trying to tax that inheritance to the New Jersey resident. And so far, the U.S. Supreme Court said, nope, can't do that. We're going to be based on the law of the state where the trust was created and where the resident was, where the decedent was. So it was a really important case, actually, to make sure that, and that's what we always believed to be the case, but New Jersey was trying to collect extra taxes, and they said, no, you can't do that. So. All right, then some of you will have an asset protection trust, completely separate trust. If you have one of these, it means you have two trusts, okay? So you'd have to look in your binder and you'll see there'll be one that says revocable trust and then a separate tab that says irrevocable trust. And I know those terms seem very close together, revocable and irrevocable, but it's the irrevocable one that's the asset protection trust. Sometimes we call that a lockbox trust because we're really locking up assets. Now, whenever you lock something up, you have a key, right? So who holds the key? Well, who you gave it to, which is usually one of your children, right? One of your children would hold the key, so they would be able to help you access it and get that out of it. For some of you, you even have a trust that you're in charge of, but you don't have both the keys. In other words, in order to get money out of the trust, you need to go through one of your children. So some of you have this type of trust also. This is the type of trust that sets things up to be able to protect those assets from a nursing home. There's good and bad in it, right? There's good in that it could protect the assets from a nursing home. There's bad, and you have to give up some level of control over it, right? That you have to rely on somebody else to get it. So you wouldn't want to put all your money in one of these. This is only for the extra. It's for the cabin up north. It's for the money that you don't think you're ever going to need. It's those types of things, all right? And it's an optional thing some people do, and you can decide whether it's appropriate for you. After the annual meeting, sometimes we'll have lots of people that don't have this, and they'll come back and say, well, we don't have that, we want it. And my preference is that let us, you can put that on your sheet there, we'll look at it, but rather than having you schedule an appointment and come in and say we want it, I'd like to do the analysis first and decide whether it's necessary or appropriate for you to come in. Because when we look at your assets and we look at your age and we look at other things, sometimes we just say, this isn't appropriate. This isn't going to be a good choice, and so we're not going to do it, basically. And it's based on the nature of assets that you have and how much of them are retirement assets and things like that. But it is something that some of you, when you came in originally, you said, well, we're not going to do that now, this asset protection, but we'll think about it later. Well, it's later, and you might want to think about it, and if you want to make sure that you have assets that are protected from the nursing home no matter what, you can consider that. What we'll do if you say you want to consider that is we'll look at the information that we have about you. maybe ask a couple questions, and then from there we'll decide whether or not it's worth it to have you come in to explore this further, okay? All right, so that was a lot of information, but that was basically mostly a recap for most of you. Most of you have heard all of that before, but we have decided to do this. We rarely do this. I think several years, it might have been like 10 years ago, we did this for Thanksgiving, and we said that we would have you be able to give this to your family for Thanksgiving. Well, we're doing this again, and we haven't done this in quite a while, but on your table or in your packets, there should be a, do I have one up here, Katie? Not necessarily. Yeah, I have one, thanks. Okay, there should be what we call a discount coupon. And so, like I say, we don't usually do discounted services, but we decided for those of you that are coming to the annual meeting and you've been diligent about making sure things are up to date, that we want you to have the opportunity to pass this on to a family member, a friend, a neighbor, somebody that you think needs to make sure they get their ducks in a row. And what we're going to do is, this is for new clients only, so you can't really use this towards making changes to your documents or things like that, but it's to make sure that if you wanted to have a friend come in, that they'll save some money on our legal services. $100. It does have to be scheduled before January 31st of 2020. We like to put, if we're going to do something like this, we don't want it sitting out there for 10 years. So there's a deadline, January 1st, 2020. That gives you plenty of time, but we do encourage you, if you're willing, and you're sort of our favorite people, the people that come to the events that we put on, and so hopefully you think highly of us, and that you would want your even your kids. Some people think, oh well, my kids are younger, they don't need this. Well, we're gonna show you a video in a minute of what can happen if you don't do proper planning, and the idea is sometimes even if they don't have a lot, they should at least have those lifetime documents that Melissa talked about. They should at least have a healthcare document. They should at least have a power of attorney. Any of you that have worked with us in crisis situations where one spouse or a parent is dealing with a long-term care situation, you'll remember that if we don't have a power of attorney, it makes it so much harder and sometimes impossible. Usually we come up with some solution, but it's so much more difficult if we don't have a power of attorney in place. And so we're going to be rolling this out next year. We didn't have this in place this year for when people were going off to college, but we're going to start rolling this off next year, of having a package that we'll put together. We call it the empty nest package. So it might be your grandkids or whatever, but if they're going off to college, they should have a power of attorney. If they're going off to college, you don't have access to their medical records. If something happens, you don't even have access to the be able to make decisions for them, or access to finances or anything like that. So the empty nest packages, the 18-year-olds going off to college, they should have a power of attorney. They should have, and we'll make it as easy as possible. We know the 18-year-olds are not going to be overly interested in coming in for an hour-long meeting with a lawyer, and but it's important. And so we're going to try to put this together next spring, so that if we have parents that are sending their kids off to college, they have an easy way. They come in, we'll make it as simple as possible. They'll sign some documents, and then you'll have some peace of mind that if something bad happens, you can still access information. But my point on telling you about that is even 18-year-olds should have some kind of estate planning, even if it's just a simple power of attorney or a healthcare document. So that's the discount that you can use up until the end of January. We are going to bring up Kelly King-Penner, attorney extraordinaire. Kelly has been with us for a while now, but if you've worked with Kelly, you know how fantastic she is. She's been just a huge addition to the office, and I can't say enough good things about Kelly. The interesting thing is that we actually came from the same law firm. It was just about 20 years apart. But we both worked at the same law firm immediately prior, me immediately prior to starting my own law firm, but Kelly immediately prior to joining us, and kind of got similar training and things like that. And so it's been, she's been a fantastic addition. And you can see whenever I have a question, I go say, Kelly, what do you think of that? Because, especially anything involving real estate. So we're going to talk about some of the hot topics and law changes, and we're going to start off with Kelly.
Good morning. All right, so Aretha Franklin, right? We all know her. All right, so she passed going on about a year and a half ago. Her estate is still going on. She had no will, no trust. Her children are fighting it out in the Oakland County Probate Court. And again, this is all public record. So this is kind of one of those learning lessons. Celebrities, time and time again, we see them passing away with no estate plan. This is going to cost her estate millions. And it's not going to be settled anytime soon. Like I said, this has been going on at least a year, and there's no sign that that's going to be coming to a close anytime soon because her children are fighting over everything. So this is one of those learning opportunities we look at this and go, okay, I don't have Aretha Franklin money. If you do, great. Planning is important. It doesn't matter what's going on in your life. It doesn't matter if you have Aretha Franklin money or you've got two nickels to rub together. You still have to have documents to make sure that you're taken care of. And that's one of those learning opportunities in the news that we can kind of pluck from and say, okay, this is the worst case scenario. Doesn't matter if you have Aretha Franklin money or not. Your family could still fight and draw this out for years upon years and for everyone in the public eye to see. So this is important to remember. You guys all did your planning. What about your kids? Make sure that they don't have to go through Aretha Franklin troubles or Prince troubles or Michael Jackson troubles. We see this time and time again. So this is one of those good learning opportunities to remember. All right, now on a lesser fun note, Bob's going to talk about the Secure Act with you.
So there is, I always joke about how we keep sending people to Lansing and Washington, D.C., and then once they get there, they figure they got to monkey around with stuff. So this is one of those things that the Secure Act actually has some really positive things in it as far as for people being able to access their retirement accounts without penalties under certain circumstances. But sort of hidden in the Secure Act is some provisions about what happens to your retirement accounts after you die. Now, this, again, there's different versions of this, so it hasn't passed yet, so we don't know exactly what it's going to be, but it seems very likely that this is not going to be an issue about passing your retirement account or your IRA on to your spouse, that they still have the same spousal rollover options. We're not worried about that. There's been no indication that they're going to monkey with that. But what it seems extremely likely they're going to do is make it so that we talked about this a couple minutes ago. If you have a retirement account, if you set it up right, we can stretch that over years and years and years. So a lot of people, one generation, if you worked for GM or whatever, you had a retirement pension. You got a monthly check. But then after a while, they stopped doing that. Like, there's not very many companies that offer monthly pensions anymore. What they do instead is they say, okay, we'll let you put your money into an IRA or a 401k. Well, now that accumulated money, if you still have that when you die, right now under the law, we can have that go on to your kids, and they can take it out over 20, 30, 60 years, depending on what their life expectancy is, if it goes to grandkids or things like that. They are looking to shut that down and make it so that it's a 10-year payout, period, that the maximum is a 10-year payout. Well, there's a couple problems with that. So a lot of people, they might not have any pension at all, but then they've accumulated a decent sum. In fact, maybe a lot of folks that we see, that's pretty much everything. They've got a couple $1,000s in their bank, they got a house, and then they've got their retirement account, and that's everything they have. And the thing is, then if they die and they still have a substantial account, having to pay the taxes over 10 years means that they're going to pay more taxes than if they could have spread that out over a longer period, right? So that's not an ideal situation. It is what it is, and we'll comply accordingly if they pass it. The issue that comes up is many of you appropriately decided that we should have your legal documents line up with the law and say we're going to get the best tax advantages we can. If we can give more money to the kids and less money to Uncle Sam, that's a good idea, and you've set up your estate planning that way. If they pass the Secure Act, we're going to have to update those estate plans. And so it's going to be one of those things that, and I think they're going to pass this law, that some point this year you're probably going to get an urgent letter from us saying, we might have to update your estate plan to revise for the Secure Act if you have any retirement accounts, if you have any IRAs, 401ks, things like that. And it's gonna be so important to do it, because if we don't update it, it means we're gonna pay higher taxes if we don't comply with the Secure Act. So it's just one of those things you can't predict, you can't plan around, and that it means that you're gonna have some legal fees associated with the update, because there was, when we drafted that plan, it was the best plan that you could get for making sure you're going to pay less taxes. But now, if they monkey around with the law, we're going to have your update your documents to comply with that law. So don't be surprised. Now, it has not passed yet, so we don't know what the final version is, and we hope that maybe there'll be some cooler minds thinking it through and deciding that they want to make sure they exempt trust, or that they figure out some other way and we won't have to do it. So I don't want to be too alarmist here. I do want to let you know that if in fact it passes and they don't make substantial changes to it, you'll probably get a letter from us saying we need to take a look at this and probably make some changes to your documents. So there's several questions that we still have about the proposals. Right now, it would apply to the Roth to the extent that you've already paid the taxes on the Roth, but the benefits of the Roth wouldn't extend beyond 10 years, is the idea behind it. So yes, that's our expectation. Now, we're hoping that there'll be an exemption, and there is currently, it's just a poorly worded exemption, for special needs trusts. So the problem with, if you have a retirement account and it goes to a child with special needs, or a trust for a child with special needs, that if they don't have an exemption for it and we have to pay this out over 10 years, that child's going to lose their medical benefits. That child's going to lose their disability benefits. And so there's an exemption written in the law to make sure that doesn't happen. It's just a very poorly worded exemption, and we at least hope they'll fix that, because it just wasn't well thought through. So we will let you know when we know more. Yeah. Yeah, that's so. Some of you have done tax planning for your IRAs as part of the trust. Some of you, we recommended that you just, but your choice basically, that you just used beneficiary designations. If it doesn't list the trust as a beneficiary, then this won't affect you. Okay, if you just use your kids as beneficiaries, but don't take that lightly, because a lot of people think they listed their kids, and then we look and it says it lists the trust, and sometimes it's actually kind of difficult for us to, is this actually a retirement account or is it not a retirement account? So just don't take that lightly and just assume that you have the kids listed as beneficiaries. You want to double check that.
All right, joint accounts. If any of you have ever heard any of us speak, we talk about the dangers of joint accounts. The Court of Appeals recently had a case that highlights this, and it's got some really interesting facts, but those facts can easily be applied to numerous circumstances. So there was a gentleman who had a lady friend. They were not married, but he had substantial assets, and over the course of years, he added his lady friend onto his accounts as a joint owner. Well, then he got sick, and she took all the money. She took all the money out of those joint accounts, put it in her own account. So she took everything and essentially ran. His family, after he passed, filed a lawsuit to try and get the money back and say, I wanted to share my money with you. I didn't say take it and run. And they had to go all the way up to the Court of Appeals to fight it. Court of Appeals eventually sided with the family, but an appellate case takes a long time and a lot of money to figure out. So how could this have been prevented? He could have had good estate planning. We could have put assets in a trust and not had a joint owner on it. So in these particular set of facts, we're dealing with a couple. This could easily apply to you adding one of your children, you adding a friend as a joint account holder. Yes, that does give somebody else management of your accounts. There are a lot of times people do this in place of a power of attorney because it's easier, right? Go down to the bank, add a name to the account. Well, what happens if they take the money? Or what if they're perfect angels, but they rack up a ton of debt, or they get sued and their creditors come after that account? If their name is on that account, their creditors can reach it. So this is one of those cases, again, that highlights the danger of joint account holders. It is an answer. It is not a good one. Proper estate planning can make sure that you have somebody that you trust that can have access to your account and management for your lifetime and after your death without all of this extra hullabaloo. Save yourself the court of appeals. You do not want to be a hot topic. Remember that. Hot topics are expensive. Save your family the headache of going through that, and save yourself the headache of going through that. Don't do joint account holders. If you have questions and you're not sure what's the best way, call our office. We'd much rather deal with the question than the possible headache.
That's a good segue because we actually were in the Court of Appeals this year, and we don't want to be. And I say that because normally we make sure that we're driving the straight and narrow, right? And that we're not going to want our clients to be the guinea pigs. Let other people do that, or if somebody volunteers to be a guinea pig. But the problem with that is we don't always have a say in it. And so when the government comes in and they decide that they're going to appeal, we're going to stand behind it, which is exactly what happened. And we had one of our successful cases that got appealed by the state. So it wasn't something that we said, okay, yeah, we're going to take this to the Supreme Court. We're always going to find the best, most efficient way. But if the state says they're going to appeal our successful decision, then we're going to defend it. And we did, and fought the good fight, and we were successful in getting the law confirmed, what we knew to be the case, and what the law said what we knew to be the accurate case, and the court decided that the law was what we said it was. And so, but like Kelly says, that is not our ideal. Ideally, we don't have to put clients through that, and we normally wouldn't, except we're not going to back down when the state's trying to push us around. So that is what happened. We were successful in getting the law affirmed, what we knew it to be, and that is an important case for everybody else, so that we can still do what we call protective orders. And the idea of a protective order is that they put very strict limits on what, if your spouse is in a nursing home, what the other spouse can have. But the court can look at it, and the Congress and the United States government, the federal government, had set this up long ago to say, well, but sometimes that's not fair. Sometimes these strict rules aren't fair, and so they said, well, we should leave an option for the local judge to look at the circumstances and say, okay, we got to do something that's fair here. And that's what a protective order is. We're going into court and we're saying, okay, in this particular case, it's not fair, these strict rules, and we got to make sure that we protect the non-nursing home spouse. And that's what a protective order is. And we've had quite a few of those. They're getting a bit more challenging, and the state's coming in and trying to cause trouble more and more. But the really good news on that is we actually might have to be able to use these less now, because a group that I'm involved in had taken another case to the Michigan Supreme Court, and we had raised some funds for a litigation fund to make sure that we could do these types of cases. And we got a unanimous decision for the Michigan Supreme Court allowing us to do spousal protection trusts. And so it just came down, 6 months ago, something like that. So all of the chips haven't kind of landed where they need to land yet, but it looks very likely in the near future that we'll be able to use that strategy again, where we can do a spousal protection trust to make sure that a spouse doesn't get impoverished because of their husband or wife's illness. So that's a very good thing, and it was a unanimous decision by the Michigan Supreme Court, which, and frankly, we were all shocked by. But it tells you the strength of the arguments that we have, and that both sides of the aisle decided unanimously in our favor. So, next is...
Yep. So, good question. Still not recommended. Not as dangerous. You don't have to worry about her taking the house and running per se, but there are some other long-term care consequences and some other consequences to consider. So, same kind of idea with the creditors. Creditors could put a lien on your house. It might affect if you needed to qualify for long-term care benefits, those Medicaid benefits that we were talking about. It's generally not recommended. There are better tools that we can go about this. Your trust, primarily. Your trust allows for lifetime management and then post-death administration. That's usually the better route to go. Don't have to worry about her running off with the house, like I said, but there's some other considerations.
Just real quick. Yeah. Yeah. Like, yeah, like a construction thing. So let me just say this, just to be very clear, because Kelly made all the logical arguments. I will say in no uncertain terms, if somebody comes to us and say, I want you to prepare a deed where we're just going to add my daughter to the deed, both of us will say, no, we're not going to do that. In other words, yes, she's saying it correctly. It's not recommended, but not only is it not recommended, it's going to be, in our idea, a bad idea so much of the time that we'll refuse to get involved in it. We're not going to say you can't do it. You can do it, but you're going to have to go to another attorney because we're not going to participate, just because we've seen so many times where that went poorly.
All right, home insurance. We kind of touched on this last year. I just want to reiterate this for those that weren't with us. If you have a home that has a home insurance policy on it and your home is owned by your trust, please make sure that your trust is listed as an additional insured. What happened is the Court of Appeals had a case where a gentleman had a home. It was in his trust. He had an insurance policy. He died. After he died, there was a fire on the house. Up in flame. Family went to go collect on the insurance policy saying, look, Dad had insurance. We want to make sure it's covered. Insurance company says, no, we insured Dad. We did not insure Trust. Trust owned the house. They refused to pay. It's not something you want to deal with the insurance company. If you have a home and it is in the trust, contact your agent and say, I want to make sure that my trust is listed as an additional insured. It shouldn't cost you anything more. It's an extra item on your policy. You're good to go then. Please make sure that you've done your due diligence and make it easier on the kids. Your home might be one of your bigger assets. Don't let it go up in smoke, literally.
Yeah, and that's a belt and suspenders kind of thing. Just do it. We could have theoretical discussions about whether that case was decided or whether there was some nuance in that case, but the answer is it's such an easy thing to do. Just do it. Yeah. Yeah. There's two reasons why you might want to consider having life insurance in the trust. One is if it has a cash value. Because if it has a cash value and we end up going to a nursing home or something like that, we might need to move it around, and it's going to be a heck of a lot easier to move it around if the cash value of it is titled to this trust. Second reason is, and that's to put the beneficiary as the trust, and that's more of an optional thing if we have the beneficiary of the trust. I recommend it because I like order. I like things like everything goes into one place. We got one or two people in charge. We get the bills paid. We divide everything up. Whereas if the life insurance goes into the trust, that means that everything gets consolidated in one place rather than having different rules for each asset or each addition to the trust. So I just think from a from a convenience and orderliness of it, to have the trust listed as the beneficiary makes it so that we're going to have clarity and of management of the asset to make it a little quicker and easier to have everything dispersed. Okay. All right, so we'll quickly touch on the VA stuff. We did that last year. It was sort of the big red alert last year. We've got about not quite a year under our belt now with the new VA rules. You can still qualify for VA. We can still help you plan for it, but now if we're gonna do any planning, we gotta do it like 3 years in advance. You can have a house and 2 acres. You can have 127,000 or 129,000 now. I think it's 129 now, and you can have as many cars as you want. You can have, But the bottom line is, we don't have the planning options that we had before, where we could do a special trust and then apply for veterans benefits the next day. Now we have, if we're going to protect assets in a trust, we got to do it 3 years in advance. So it's one of those things that if you were counting on relying on veterans benefits in your in later stages of life, because you want to make sure that's going to pay for home care or assisted living or memory care or anything like that, that's one of those things where we would look at that asset protection trust now when we don't need it, because we'd want to try to have that in place 3 years in advance. Okay, question? Yeah. Yeah, and we can actually disclose. In fact, now we have to disclose it. We'll say, yep, we put assets in this trust over 3 years ago. In fact, it doesn't even have to be over 3 years ago. It just has to have been prior to October of 2018. So anybody that had this done prior to that was grandfathered in. So if you remember last year, we made a big push to say, anybody's interested. We actually even did extended hours at our office, and we're there till like 9 o'clock some nights, where anybody that wanted to get in before got grandfathered in before the change, we got you in and got that done. So, yeah. Yep. So you can come. Why don't you come talk to me on that, because that it's a very precise thing that they're saying, and the thing that you're saying that you're referencing is income. What's weird about that is the VA doesn't define income the way you and I define income, and so that's something we can work with you on to say, okay, this is what they mean by income, and this is how we can change that. Because what they define income as income minus medical expenses or long-term care expenses or assisted living expenses or home care expenses, things like that. So it may be true that even under their rule that you're to have too much income right now, but if we end up paying for assisted living or paying for home care, then you wouldn't, because now they're going to be able to subtract that from your income in that determination. So there's a lot of words that the VA uses that aren't common English, and they just have completely different, way of looking at it. Yeah, even just come talk to me one-on-one, and we'll work through it to see whether it's something that is. Even just come talk to me afterwards today. Yeah. Okay. Okay. Well, I do want to cover one thing here, and I know we're hitting close to an hour and a half here before we do the memory jogger, but this was just such an important issue that I wanted to talk about it. Maybe some of you have seen this, but this is. I don't want to say this is rampant, but we've seen some things that happen throughout various courts and I'm not complaining about any particular judge or anything like that. I'm just saying probate in general, when you end up having to go through the system and having the courts involved in it, sometimes the results aren't so good. And here's an example of a big case, and it's actually gotten national attention and things like that. The governor's been very active in this. The new attorney general in Michigan has gotten very active as they have this. Have you heard of the Elder Abuse Task Force? Well, one of my close friends, or a couple of my close friends, are actually on the governor's task force. But it's to deal with these types of things. But my point, and the reason I want to show you this, is the example of how things can just get out of control if you don't have proper planning. So this family should have absolutely had a trust and a will and a power of attorney. You've done all of this. So this is basically to show you what you've protected yourself from, and to encourage you to tell other folks that they should protect themselves from this kind of a thing where courts run rampant over people's rights. So here's the scenario.
We get a lot of calls from families whose loved ones have been placed under guardianship, and unfortunately, we can't tell every single story. But this one caught our attention because of a fence that was built and because of the history of the judge involved. This is the tale of two fences, one holding what family members say are two vulnerable adults inside their home, the other protecting the huge home that belongs to the people now in charge of making all financial and medical decisions for Barbara Delbridge and Bob Mitchell.
They don't want us to see in, they don't want them to see out. So it's a perfect way to hide them back there.
Barb and Bob's family members say after Macomb County probate judge Catherine George appointed Caring Hearts Michigan Incorporated as their guardian, the caregivers put up this 6-foot-tall privacy fence. The caregivers say it's for Barb and Bob's safety, but relatives who live right next door say it prevents them from communicating with their loved ones.
I just want my parents back. I want them to enjoy the retirement that they should have had prior to this company taking over.
Marcy Mitchell tried to become her dad and stepmom's guardian last November because both were becoming mentally incapacitated. Is everyone in the family on board with Marcy being the guardian?
Absolutely. We were all 100% behind her.
Even though Michigan law gives Marcy priority to become a guardian to family members, Judge George told Marcy she had grave concerns about Bob and Barb and instead handed their lives over to Caring Hearts Michigan and its owner, Kathy Kirk.
How did the judge make you feel?
Like a bad daughter. Like I wasn't there for my parents enough as I should be.
Marcy says Kathy Kirk promised she would stay involved in her parents' care, but in April, she was barred from seeing them. Kirk hired another company that she owns called Executive Care to provide in-home caregivers 24 hours a day.
They're comfortable there, they're healthy, they're being taken care of. We have detailed food logs for the food that they're being served. So Executive Care has come in and tried to stabilize this situation.
Kathy is married to Robert Kirk, a Macomb County public administrator in the probate courts. Both Robert Kirk and his law partner have donated to Judge George's campaigns in the past. Just like Marcy can't talk to her parents behind this fence, we couldn't catch up with Kathy Kirk because she too lives behind a fence, a massive privacy gate walling off their large home from public access.
Good morning, everyone.
Members of the Franklin family say Judge George also appointed Caring Hearts when they tried to get guardianship of their 89-year-old mother, Piera. Mrs. Franklin is now back with her son, but only after her family members say they too were prevented from seeing their mom.
Who was she with when she fell at the restaurant?
I believe she was with one of the caregivers, one of the healthcare aides, and I believe it was a trip over a curb.
This isn't the first time questions have been raised about Judge George and a guardianship company. According to this order from the Michigan Supreme Court, back in 2008, they removed Judge George as chief judge.
All right, that pretty much kind of tells you the story. I'll fill in a couple of the other facts here. They had family. The whole family was in agreement that this person, that the daughter should be the guardian. She had the legal right to be guardian. She had priority over anybody else. And the judge appointed a stranger, a company. That company hired their own caregivers that from their own company, hired her husband as the lawyer. They spent over $300,000 of that family's money in 6 months. I think it was like $350,000 in 6 months. And so my point on it is when people just think, oh, I don't have a lot, or, it's not a big deal. My family will take care of it. This family tried to take care of it. Yeah, they tried. And when the court system got involved, they lost all control. Now, how could that have been avoided? A trust, power of attorney. We've had this happen a few times where one of our clients got called by APS, that somebody came in and said, oh, well, this mom's not being cared for and things like that. And Adult Protective Services, so you have Child Protective Services that can come and take your kids. We got Adult Protective Services that can come and take your parents. And so Adult Protective Services got involved, and then the client called us, and we would call up Adult Protective Services and say, nope, we got it under control. Here's the power of attorney. Here's the trust. Here's the authority. We got everything under control, and they went away. And so the idea is, there's lots of folks, I understand, that aren't comfortable going to see an attorney and don't like going to a stuffy office, and they think that it's just going to be fine because there's family, and that's the way it was with grandpa, or that's the way it was with, well, the world's changed, and there's lots of folks out there that aren't necessarily looking out for your best interest, and so you got to do that. You got to do it yourself. Now, you've all done that, so that's good. I think we've arguably protected you from that kind of garbage, but that's if for folks that haven't done it, you never know what's going to happen once it gets into the court system, and having the family lose control is a possibility. Yeah, happened. Yeah, guardian. So one other thing I want to touch on real briefly, and many of you have noticed or heard about this, there's the change in the insurance law, the car insurance law. So in Michigan, and I'm not sure that it got the attention it should have, but at Michigan, they always complained about our car insurance is too high, right? Well, I understand that's a problem, and that, like if you live in Detroit, it's extremely high, and they were trying to fix that. So they did this insurance reform law, but what they took away from it was the catastrophic coverage. So up until recently, if you got in a car accident in Michigan, then the insurance company, Blue Cross, or whoever the insurance company was, not Blue Cross, it would be the insurance company, AAA or whatever it was, the car insurance company, had a fund, and they would make sure that if you need 24-hour care, you were going to get 24-hour care. If you needed in-home care, you were going to get in-home care, that your rehab would be paid for life. It wouldn't just be for 6 weeks or whatever. And so they made that now optional. Okay, here's what the problem is making that optional. You can opt into that, but just like Lisa talked about with the Medicare supplements, if it's it's going to die on the vine, because if not everybody opts in for it, then that fund's going to dry up, and it's going to be so expensive to opt in eventually that fund's just going to go away. And it's a real shame, because what they said is, oh, we don't need this fund because we've got Medicaid. So any of you have any experience with Medicaid, it's an important program that we have to make sure that we don't go broke, but it's not going to pay for 2 caregivers to stay in your home with you like this other program did. It's not going to pay for lifetime rehab, physical therapy, occupational therapy. It doesn't pay for those things. So now they shifted this burden of car accidents away from the insurance company onto the taxpayers. So how is that good for us? It says we're going to save like $50, on our car insurance now, but now our tax rates will go up because they basically took this burden away from, it was part of the insurance. The insurance companies were mandated to have this, and insurance companies had to pay it. Now that fund's going to die on its vine, and what their answer to that was, that's okay because people will just get Medicaid. Well, first of all, the coverage is much worse for Medicaid, and secondly, now they're just shifting the burden over to the taxpayers instead. And so I encourage everybody, it is what it is. The law passed. It was bipartisan. I'm not even getting political here because both sides supported this. It was overwhelming support because they were going to lower car insurance prices. And the question is whether that will actually happen. But what I'm encouraging people to do is opt in for that coverage. At least while we can, opt in for that coverage. Might cost you an extra $200 a year or whatever. In a few years we might not be able to afford it, but for now I'm encouraging you to opt in, because if you got in a car accident, you're going to want that coverage. Yeah. For Medicaid, it's 5 years. So what that means, though, is you shouldn't give money away, period. If you're going to give money away, anything large sum, you should at least have a consultation with our office to discuss it and see if we can come up with a different way that won't affect it. So the look back period, what we're talking about is whether you can give money away and still qualify for Medicaid at some point. And my answer is just don't do it. Don't give money away. And if you're going to, you're going to give $30,000 away to your kids or $10,000 to your kids. A lot of people think, I can give them $10,000, right? No, that's a tax law. That's not a Medicaid law. So if you're going to give $10,000 away, have a 5-minute conversation. Call up. We'll schedule a time. It might not be 5 minutes. It might be 15 minutes. But let me see if I can come up with an alternative that's not going to have the negative legal consequence of just writing that check for $10,000 or $30,000. Okay? And a lot of times we can come up with an alternative. First, I'm going to discourage you from doing it. So understand that. I'm going to say this is your money. You should keep it. But I'll say it. But it's your life, and you do what you want to do. And if you're going to do it, let's document it this way, and not if we document it right, it's going to make it a lot easier, and we'll be able to work around that 5-year look back period. Yes. Yeah, interesting that you mentioned that. She said prepaid funeral. So at the successor trustee workshop, we are going to have representatives from Martin Funeral Home. Where's Savannah? Martin Funeral Home is going to be there. So if you're going to be sending any of your kids to our successor trustee workshop, which the dates are on your table, we're going to have representatives from Martin Funeral Home, which is right across from our office in Grand Blanc, and they're going to be talking to folks about pre-needs planning or prepaid funerals. So excellent source of information. Yeah. Good question. So is a trust in Michigan still good if you move out of state? And the answer is yes. Still might want to have it looked at by a lawyer there, but the answer is it's still perfectly valid. It's just going to follow Michigan law even if you're a Florida resident. So that's perfectly okay. I do want to spend a little bit of time on this memory jogger. This won't take very long, but I want you to pull this out. So it says Memory Jogger 2019. If you leave with this, you made a mistake. You should not be leaving with this document. This is for you to fill out right now and turn it in. And all of the folks are going to be lining up all over the place with the gray shirts. And then Gregory is a black shirt, but everybody else has the gray shirts, and you just hand it to one of them before you leave. Because this is your report back to us as to whether or not we need to contact you about any updates or anything like that. So we're just going to go through this. You got to put your name on it. If it's all no's, we're not going to call you. So we'd still like you to turn it in. So if we go through this and you have all no's, we're not going to call you. If you have any yeses, we're probably going to check in with you. Okay. So the first thing is, in the last year, have you have any changes in your financial assets? Did you get a new bank account? Did you switch credit unions? Do you have a new financial advisor? Did you open up new life insurance? Did you buy any new real estate? Yes or no? Has there been any significant deaths? In other words, your direct child, did they die? Yes or no? Obviously, if your spouse died. Has there been significant changes in your health? And what I mean by that is a likelihood of needing nursing home in the near future, like a diagnosis of dementia or Alzheimer's or Parkinson's or something like that, some of those dreaded things. Changes in your health, yes or no? Changes in your marital status. Obviously, we need to know if you got divorced. Did you buy a house or sell a house or other real estate, yes or no? And any other concerns you want to discuss with us. So that was quick and easy. Yeah, those are the things that we need to know about. And if there's any yeses, you want to turn in. If they're all no's, we'd like you to turn it in anyway. So we'll save this in your file, and then we'll know that you were here and we checked in with you. But this will take you 5 minutes to fill out. Put your name on there. If you're not getting emails from us, we'll make sure you get on our email list if you have an email. And 5 minutes, fill it out, turn it into any of the folks in gray, and then you're good for another year. If you have any yeses, expect, it's going to take us a couple of weeks to get through all these, but we'll if there's any yeses, somebody will give you a call and we'll just check in with you further. Okay? Anybody wants to come talk to me one-on-one, feel free to do so. I think there's a question over here before we close things up. Yeah, I'm sorry. Very good point. Thank you very much. So several things. So we have our swag this year. We always try to give you something. So this year is these water cups. So there's about 4 on the table. We know not everybody's going to want one, but grab one, and I'm sure there's extras. There's a few of our cool sunglasses. I actually like these. My kids love them. That have our logo on it. But most importantly, how do you watch this presentation again? So we're trying something new this year, and we'd really like you to try it. There is you just go to our website link. And so where do they find that website link, Savannah or Katie? Is it going to be, is it in their materials? Okay, so here it is right here. So this is it, mannorlawgroup.com/annual meeting. You will go to that link, and it'll be up probably 3-4 weeks. And so you go to that link, and you'll be able to watch this presentation all over from the beginning to end, and you can fast forward to the boring parts, okay? But this is it, and you can have the kids look at it. So if they want, the kids can look at it. And now it's going to save us a bunch of money from the cost of mailing out those DVDs. If you can't do it, if you're just say, I don't have anybody that can help me with the computer, and you can't do it, and you absolutely need that DVD, call us and we'll mail you a DVD. We're just trying to cut our costs here and make it easier so you can just go to the computer and look at it there. But if you absolutely say, I can't figure that out, I can't do it, I really want the DVD, we'll send it to you. We're just trying to cut our costs, yeah. Yeah, so what we're going to do now, we're still going to do those in-person ones. We really like to do it because it gives people an opportunity to ask questions and things like that. But Savannah's both Savannah and Greg are sort of our technology people, you know. And so we're going to create one that is that they're going to be able to access like this, so that they don't actually have to come to the office. So we do those successor trust workshops about 3 times a year, but we're going to do one that they'd be able to just log in and watch it, and hopefully maybe even interact with us on the computer. So look for that probably about 90 days out before we're going to get that up. But we're going to have an option for folks, your kids, whatever, to log in and watch the successor trustee workshop or a version of it. It's not going to be live necessarily. Thank you very much. Don't forget to turn in your memory jogger, and I'll be around for anybody that has any questions one-on-one.